Amy, a Hong Kong entrepreneur, started her business small. She loved baking and dreamed of sharing her passion. Her signature creation, a strawberry cream puff with a delightful pink hue, quickly gained popularity. Customers began calling her Pinky Girl due to her pink-themed treats and packaging. Embracing the nickname, Amy rebranded her business as Pinky Girl Bakery. Her unique treats and branding resonated with customers. The business flourished, expanding beyond Hong Kong's borders into mainland China. The only problem was that Amy never registered the Pinky Girl Bakery trademark in Hong Kong or China. Meanwhile, an Italian confectionery giant, named Pinky Girls, also set its sights on the Chinese market 2 years later. The Italian giant was very keen on brand protection and registered its Pinky Girls trademark globally, including Hong Kong and China, since its first launch. Amy bumped into Jenny, a trademark lawyer, on the street. When learned about Amy's Pinky Girl business, Jenny reminded Amy about trademark registration and offered to help Amy on a pre-application search, which revealed that the possible Pinky Girl trademark applications in Hong Kong and China will likely be blocked by the earlier Pinky Girls registrations. Amy's situation is not unique. Countless small businesses face similar challenges when expanding globally. The lack of awareness regarding international trademark laws can have severe consequences, potentially leading to rebranding, legal battles, or even business closure. This situation highlighted the critical differences between Hong Kong's first-to-use system and mainland China's first-to-file system. The contrasting trademark systems exemplify the complexities faced by businesses. Hong Kong, following the British common law tradition, grants trademark rights based on actual use in commerce. This system favours businesses that establish a market presence, regardless of formal registrations. China, on the other hand, adheres to a civil law tradition. The first-to-file system prioritises formal registration over prior use. This approach aims to provide clarity and certainty, allowing businesses to easily determine the ownership of a mark. While both systems have their merits, they pose distinct challenges for small businesses. Hong Kong's system, while seemingly fair for early market entrants, can leave trademark registrants vulnerable to later claims, and thus post-registration uncertainty is inevitable. China's system, while providing greater certainty, can be more easily exploited by trademark squatters who register marks in bad faith, aiming to profit from the legitimate businesses that actually use them. So, what are Amy's positions now in Hong Kong and China? In Hong Kong, with a first-use system, when Amy started using the Pinky Girl mark commercially, certain kinds of trademark rights were created. Specifically, since Amy started using Pinky Girl earlier than the Pinky Girls registration, the Italian brand could enforce its Pinky Girls trademark rights against the whole world, but not against Amy. Amy might even be able to secure Pinky Girl registration in Hong Kong by establishing honest concurrent use. This means that both Amy and the Italian brand could coexist in the market, sharing the same or similar trademarks without infringing on each other's rights. By way of contrast, Amy's trademark situation is much harder in China. While China's trademark laws, in general, protect earlier rights, there is a lack of specific provisions protecting Amy's right to keep using her Pinky Girl brand in China. It is all but unknown if evidence of use would help Amy's case much for trademark registrations in China, given the high similarities between Pinky Girl and Pinky Girls. Even if Amy started using Pinky Girl in China first, very limited rights would be available to her. As Amy continues her journey, she must carefully strategize her next steps to protect her brand in these contrasting legal landscapes. Trasomark is the best mate